Good morning, sir. You Brian McWade?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Yes, Your Honor. We're pleading to the lesser included attempted.
Thank you.
Just need to see, make sure.
Okay, I'll be sure to add it.
Mr. McWade, in cause number 26 DCCR 0402, the state has elected to proceed on the lesser included offense of a third-degree felony, attempted aggravated assault with a deadly weapon from March 8th of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Macon?
Yes, ma'am.
Do you fully understand them? Yes or no?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for an 8-year deferred probation. No, I'm sorry. There would be an 8-year term in prison that would be probated.
Which I
for
believe
8
we can
years.
do since it's an attempt, Your Honor. Typically with this offense, you
Right.
can't, but I think since we made it an attempt, we're okay.
Okay. Y'all looked at it
A
a little bit.
little bit, yes, Your Honor. That's
Okay.
my understanding.
All right. So what we'll do also is between now and sentencing, if everybody will double check, just so that we make sure before sentencing that we don't do something that we're not supposed to.
It's in that big green book, I think.
I'm sorry.
It's in that big green book.
Yeah.
The big green book.
The big green book. All right. So it looks like the agreement is for an you would be convicted with an 8-year term in prison. That would be probated for 8 years. There would be a $1,000 fine, and you would be required to follow all of the rules and conditions of probation. It's checked off restitution center,
There is restitution involved, Your Honor.
but not the restitution. We don't even have that anymore. We need to change that. We don't have a
Saw
restitution.
the word
center.
restitution and checked the box.
So there's an agreement. I'm going to write that you would pay restitution. Is that correct? And the amount determined between now and sentencing?
Yes, Your Honor.
Is that, you understand that as well? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection, Your Honor.
It's admitted. Is there any evidence that Mr. McWade's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back for later for sentencing. That'll also give everyone an opportunity to figure out that restitution amount, and we'll double check that based on what the nature of this offense is, that we can do that convicted probation. I want everybody to double check that as well. So with regard to a bond based on the nature of this plea agreement, Mr. Nichols, what's the state's?
Your Honor, he served 150 days in jail. In this case, we don't oppose a bond pre-sentencing.
So, Mr. McWade, what I'm going to do in your case, based on the nature of your plea agreement, is reduce your bond to $1,000. If you make that bond, there's a couple of things that are very important. The first is that you go directly to the probation department when you're released so you can get that pre-sentence report done. If you don't do that, you run the risk of me not accepting the plea agreement, and things could be worse. Also, if you are arrested for anything between now and when you come back for sentencing, you run the risk of me not accepting the plea agreement. And then the last thing would be, a condition of your bond is that you have absolutely no contact or communication with Simone Mullins. That's obviously communication in person, but it's anyway. You can't send messages through any type of social media or other people or anything like that. If you do, and I find out about it, then your bond will be raised, you'll be back in jail, and I probably won't accept the agreement. All right, any questions? All right, good luck to you, sir. You can go back with the bailiff. We'll see you at sentencing.
Thank you, Your Honor. Mr. Megan.
Could you please make a note? Because I feel like I'll probably be on the take some.
In the end, the defendant walked away with a $1,000 bond and an 8-year plea agreement. But the judge made it clear that one mistake, one new arrest, or any contact with the protected person could put the entire deal at risk.